So we've been talking about a lot of documents recently, but today we're going to be talking about some documents that are also important, but they're going to be on the closing end of your purchase. So historically, we were talking about documents that are going to help you acquire the property, some of the documents that you'll be running into in order to get everything to the finish line. So in order to finalize everything at the finish table, you're going to have some closing documents that you're going to need to review and make sure everything is covered. So let's get to it. The first one you're going to see if all of your hard work in your due diligence period is done, you're going to see a closing statement. These are also known as settlement statements. These bad boys are going to summarize the financial transaction in the purchase. You're also going to see these types of documents when you are refinancing a property. A lot of banks are going to send everything to a title company, and the title company is going to send you this statement in order to give you all the numbers that are going on within that transaction. So closing statements are going to outline all your costs and payments in order to give that transparency and accountability for everyone that's involved in the transaction. These documents are going to be prepared by your escrow agent, sometimes maybe your closing attorney. In the closing statement, you're going to see the purchase price, you're going to see a loan amount if you're getting a loan, you're going to see taxes, which are hopefully prorated, you're going to see insurance, which is also hopefully going to be prorated, and miscellaneous fees, title fees, and lastly, probably closing costs. And it's going to be a breakdown between the seller and the buyer. It's going to specify the amounts that are owed by each party and the records that have been made of payment in order to confirm that there has been correct allocation of funds. So you're definitely going to want to review this in detail, make sure all the numbers are right, make sure you've paid everything correctly, or whatever you owe or the seller owes you is all spelled out in the closing statement. And at the closing table, both parties are going to have to sign this settlement statement. Next, we have what's called a deed of trust. They're also called trust deeds. These are used in some states to secure mortgage loans. So how it works is that the borrower or the trustor transfer the property title to a trustee who essentially holds it as collateral. So if the borrower or trustor defaults for whatever reason, the trustee can sell the property without a court order. So in a sense, it cuts out all that necessary bullshit with the law, or with court, I should say. In a deed of trust, you're going to see some names. You're going to see the borrower, who's the trustor again, the lender, who's the beneficiary, and the trustee. It's going to detail the property that's being used as collateral. It's going to spell out the loan term, the loan amount, the interest rate, and the repayment period. And also, you're going to see default conditions. So when there is a default, it's going to spell out when the trustee can sell the property. The trustee is going to be the one who holds the property's title, and they can sell it if the borrower defaults. Next, we have a deed, and this is going to be a legal document that transfers the property ownership. It's going to have the property description, buyer and seller names, warranty deeds, which assures a clear title. So there are three types of deeds out there. First, you have your warranty deed, which essentially assures a clear title transfer. There's also something called a quitclaim deed, which transfers the seller's interest without any guarantees at all. Then you have a special warranty deed, which offers limited assurances. Then next we have assignment contracts. So wholesalers love assignment contracts. This is how they make their money. But assignment contracts essentially allow one party, who is the assignor, to transfer their rights and responsibilities under an existing real estate contract to another party, who is the assignee. This happens when the buyer of a property wants to sell their position in the contract without actually purchasing the property. So there's going to be a couple key things in here. You're going to have the original real estate contract that was between a seller and a buyer, who is the assignor, and you're going to have an assignment agreement. So in the assignment agreement, the assigner transfers the rights to the assignee. You're going to have consent from all parties, seller, assigner, assignee. Some states are going to be different, so check your state's regulations. And a lot of times you're going to have an assignment fee, which this is how wholesalers make their money. It's going to be charged by the assigner to the assignee in order to send their interest over. And it's going to have to spell out the closing requirements. It's going to mention that the assignee is going to have to complete the purchase as outlined in the original contract. Once again, these are common in real estate wholesaling, but they're also used in situations where if you're purchasing a property and you don't yet have an LLC for the property and you put one of your LLCs on there, and eventually, and by the time closing comes, you don't want to put that property in that LLC, and you create an LLC, and now you can transfer the ownership from your existing LLC to the new LLC for protection purposes. Next up, we have what's called an affidavit. So affidavits are a sworn written statement of facts. Some of the key points in affidavits are a sworn testimony, which is where the affiant declares the information true under oath. The common uses for the affidavits are legal proceedings and some real estate transactions, maybe sometimes in financial matters, but for our purposes, in real estate transactions. It's going to include a heading, a body, and an attestation clause. And it's also going to have to be notarized for authenticity, of course. It's essentially a document that says, I swear to God, this is true. Next up, you're probably going to see some amendments. An amendment is a formal change to a legal document. They're there for updating or revising existing documents, like your purchase contract or leases or your LLC bylaws or your articles of operation or your operating docs. It's going to try to clearly state the changes to the original document that it is amending. Usually there's going to be some type of numbering system to track what the changes are, and it's going to refer to another document, so you're going to be jumping back and forth a lot in order to get the full complete picture of whatever the document is. And whoever executed the original document is going to have to execute the amendment as well. And lastly, we have what's called a memorandum, which you probably know it as a memo. These are brief written documents that are used for internal communication. It's going to look like pretty much a letter. You're going to have a header with date, recipients, sender, the subject. You got an intro that provides some type of context and purpose. You got a body with the main juicy contents that the memo is about, and probably attachments if there are any, and definitely a closing paragraph that summarizes all the key points and even next steps. And lastly, you're going to have a signature at the end. Memos are great when you want just small notes and in order to be concise, and the main reason for usage is efficient communication, if you will. And that is a wrap for today's episode. I hope you got a clear picture of some of the documents that you're going to be running into when you are closing a real estate transaction. Hopefully you're feeling less overwhelmed. And until next time, Wonton out.